The first step in a case is to try and get some understanding of what happened. Primarily, my first concern is issues of liability and responsibility in securing any type of evidence, be it investigation, photographs, witness identification, that may be important to the case. Many times experts might be required to visit the scene of an accident. It could be an engineer, an accident reconstructionist, or otherwise. There also, in some cases, are relatively short windows of time in which to commence an action. The first step in a lawsuit is the filing and service of a summons and complaint. Generally, a defendant will then forward the complaint to an insurance company, and the insurance company responsible for insuring the defendant will hire counsel to protect their interests. They will interpose an answer, generally within 30 days. Then becomes an exchange of discovery, where authorizations for medical records are exchanged, witness identification is exchanged, insurance disclosure is exchanged, any photographs, general exchange of discovery. A judge is then assigned to the case, a scheduling order is entered, and there are dates for depositions where testimony is taken of the plaintiff by the attorney for the insurance company. And we also depose the defendants and any other necessary witnesses to the case that may be under the defendant's control. After depositions are done, the defendants generally schedule a physical examination, and the plaintiff is examined by the defendant's doctor. They're not entitled to any intrusive studies, no x-rays, generally just a hands-on examination. They are entitled to review all medical records. After the depositions and the physical examinations are held, the plaintiff can certify the case is ready for trial. The case then steps into line for trial and waits for a trial date. Depending upon the county, the wait can vary, and generally, while a case is in line for trial, is the most fruitful point of negotiation to the extent that a settlement can be reached. The majority of cases do ultimately settle as opposed to go to verdict. However, it's important to negotiate from a position of strength. In the earlier stages, carriers will try and negotiate a resolution that they really think they can get away with. As a case nears trial, the carriers will tend to value a case based upon what they may have to pay if a case doesn't settle. So it's very important in serious personal injury matters to have a case properly presented and exchange to take place before a case is settled. There's only one opportunity to resolve a case. There is no coming back. So once a case is settled, it's settled for good. Generally, the reasons why parties come to a settlement is the risk of trial. One jury could hear the exact same case, and one trier of fact could decide it one way. Another could hear the exact same case and come down in a completely different direction. There are significant risks with going to trial. However, it's important that if a case has to be tried, it be tried properly and presented without hesitation in terms of costs or experts. Because bear in mind, the defendants in the insurance companies have essentially unlimited resources at their disposal. If you or someone you know has been involved in an accident, sustaining injury, please do not hesitate to contact my firm. I will personally get back to you as soon as possible. We are here to help. There is no fee for a consultation. We do work on a contingency if we're retained, but I'm more than happy to answer any questions or concerns that anyone may have in the event of an accident.